Artificial intelligence, the legal dangers of over-reliance on AI in business. The rapid integration of artificial intelligence into business operations has outpaced the development of legal frameworks, creating a precarious environment for companies that over-rely on these systems. The legal dangers of such reliance have moved from theoretical concerns to active litigation, particularly in the realms of liability, data privacy, and intellectual property. The breakdown of professional liability and accountability. One of the most immediate legal dangers is the erosion of professional standards through automation bias, where employees trust AI outputs without sufficient human verification. If an AI system generates flawed financial advice, incorrect medical diagnoses, or hallucinates legal citations, the business remains the primary target for professional negligence claims. Courts increasingly reject the black box defense, holding that businesses have a non-delegable duty of care to ensure the accuracy of their services. Relying on AI as a substitute for human judgment, rather than a supplement, often results in the failure to meet the standard of a reasonably competent practitioner. This gap in oversight can lead to malpractice lawsuits and the potential voiding of professional indemnity insurance policies that do not explicitly cover autonomous errors. Regulatory noncompliance and global fragmentation. Businesses operating across borders face a patchwork of AI regulations that are becoming increasingly stringent and punitive. In 2026, the full implementation of the EU AI Act and various state laws like the Colorado AI Act and the Texas Responsible AI Governance Act require rigorous impact assessments and transparency disclosures. Over-reliance on a single AI vendor without auditing its compliance with these local laws can trigger massive fines, reaching up to 7% of global annual turnover in some jurisdictions. Furthermore, the SEC and other financial regulators have shifted their focus to AI washing, the deceptive practice of overstating a company's AI capabilities, which can lead to securities litigation and enforcement actions for misleading investors. Data privacy and the risk of data exhaust. The massive data requirements for training and operating AI models create significant vulnerabilities regarding data sovereignty and privacy. Many businesses inadvertently leak trade secrets or personally identifiable information by inputting sensitive data into public or unvetted shadow AI tools used by employees. Legal risks are exacerbated by data exhaust, derivative data generated by AI that often goes uninventoried but remains subject to GDPR and CCPA requirements. Failure to maintain strict data lineage and privacy by design can lead to class action lawsuits over unauthorized data processing. Regulators now expect companies to prove they have obtained explicit consent for using customer data in AI training, a standard that is difficult to meet when systems are fully automated. Algorithmic bias and civil rights litigation. Over-relying on AI for high-stakes decision-making, such as hiring, lending, or insurance underwriting, exposes firms to severe discrimination risks. AI models often mirror historical biases present in their training data, leading to indirect discrimination that violates the Equality Act and fair lending laws. Because these biases are frequently obscured within complex algorithms, businesses may be unaware they are breaking the law until they face a disparate impact lawsuit. The legal burden is increasingly shifting toward the business to proactively audit and prove that their algorithms do not unfairly disadvantage protected groups. Without human-in-the-loop interventions, a company's automated efficiency can quickly become a systematic liability for civil rights violations. Intellectual property and ownership vacuums. The legal status of AI-generated content remains one of the most volatile areas of commercial law, as current frameworks generally require human authorship for copyright protection. Businesses that rely heavily on AI to create marketing materials, software code, or creative assets may find that they do not actually own the intellectual property they have produced. This creates an ownership vacuum, allowing competitors to legally use the same materials without permission because the work resides in the public domain. Additionally, there is a persistent risk of output infringement, where an AI generates content that inadvertently mimics copyrighted training data, leading to expensive infringement suits. Without a clear strategy for sufficient human authorship, a business's core assets may be legally unprotectable and commercially vulnerable. To learn more about our law firm's technology business legal practice, we welcome you to visit our website or contact our law firm to schedule an initial consultation. Thank you.